welcome everyone. So I'm Aviva. I'm the organizer for the Postdoc Union here at UCSF. I basically help organize events like this and help assist our network of stewards who are postdocs here at UCSF to be able to present things like this. So I'm going to let Layla do that. But first I want to introduce our speaker today, Stacy Gartland. Yeah, do you want to introduce the firm that you're with too?
Sure. I work for Vanderhelp, Regaliano, Nightingale. I'm a partner at that firm. I've been practicing immigration and nationality law now for more than 21 years. That's all I do. I'm a certified specialist with the State Bar of California in that specialty. I also have an undergraduate degree in molecular biology, and I worked for a genetics lab for 9 years before I went to law school. So I like working with scientists and researchers. It is one of my specialties. And our firm has been representing the union now for years, probably 15 years. So we do presentations like this one, which are designed to give you some general information about immigration law. But some of you would also benefit from a one-on-one personal consultation. And just so you know, we do offer a discounted fee for that kind of consultation. If you do want to make an appointment at the office and have a sit down where we might spend an hour to an hour and a half just assessing your individual needs.
Cool, great. So before we move on to that, Layla, are you?
Yeah. Hello, everyone. My name is Layla. You probably get emails from me.
Layla's one of our elected head.
Yeah, I'm one of the head of STAR. So if you get any questions, you can contact everyone.
And then we also have, Mariana in the room, one of our other stewards here today.
Yeah. So as you probably know from emails and meetings that about 2/3 of postdocs are international, like UC-wise.
UC-wide and maybe even more at UCSF.
Yeah. And immigration and visa policies are very important to most of us. And in work life or in our personal life, and through our union we have a public voice and try to influence some of the policies, especially the one that we are giving now about the travel ban. Most of us are affected. For example, we have worked with California Attorney General and legal challenges of the administration, like presidential administration travel ban, and also provided input for some Supreme Court case. That work and educational events like this are only possible with strong membership. So the point is, become member, have your voice with union, and let's see what we can do to face the problems and if we can solve the problem.
Yeah, so that case that you're referring to, the ACLU court case against basically telling the Trump administration that the travel ban is unconstitutional. So we had postdocs throughout the UC system actually contribute their stories to that case and how they were personally affected by it. So that is something that we as a union are able to represent you in that capacity. And since a majority of postdocs are international, you don't have your own vote. Basically, the union can kind of work in that. We're able to represent you in that public sense. So that's another reason that having a strong union is an important thing, so we can best be able to do that moving forward. Yeah, and actually, so everyone who just came in, I have some sign-in sheets I'm going to pass your way, and then we'll go ahead and get started.
I do want to echo what Layla just said. Even if you're here on a temporary visa like an F or a J visa, that doesn't mean you don't have any rights in this country. You absolutely have the right to sue even the President of the United States, and you should absolutely exercise those rights when our government does something that's against our law and our Constitution, which is the travel ban is. Also, the congressional representatives represent you as well. So if you're living in California, the senators of California and the congressional representatives also should hear what you have to say, because their job is to advocate on behalf of Californians, and that includes you, even if you're here on a temporary visa. So absolutely speak up. Don't just roll over and accept what this administration is doing. Okay. So I did get some questions beforehand filtered through Anka to me to let me know kind of what you were interested in hearing about tonight. And the majority of those questions really focused on green cards or permanent residence, how to apply for permanent residence. But there were some questions about the non-immigrant or temporary visas. So I'm going to start with the non-immigrant or temporary visas. I'm not going to talk about every single one. Those visas are labeled with the letters of the alphabet, and they go from A to B and all the letters in between. So there's a lot of different types. But only certain ones are work visas that really work well for post-grads. So we're going to talk about a few of those and a few of the special issues that are coming up under this administration. It's a little bit different this year under the Trump administration than it has been in the past, so I'm going to highlight a few of those issues. And then once we finish that, I am going to talk a little bit more in depth about permanent residence, the different pathways to apply for permanent residence that are going to be open to many of you. We're going to start with the H-1B visa. And I'm sure that most of you are aware about the H-1B visa. It is the kind of mainline work visa for somebody who's graduated with at least a bachelor's level degree. It is a visa for someone to work in a specialty occupation. So specialty occupation under the law is defined as the kind of job that would typically require at least a bachelor's education or higher in that specific field. This year, we are seeing a lot of pushback on that particular definition. What does that mean, and whether or not particular jobs require certain degrees. The U.S. Citizenship and Immigration Service that adjudicates these applications are being ridiculously scrutinizing on whether jobs meet that specialty occupation requirement. So even jobs in the past that should be no-brainers in terms of qualifying, we're seeing a lot of pushback. So senior software engineers, statistical analysts, even research scientists, pharmacists, we're seeing them come back to us and saying, prove to us that job requires at least a bachelor's degree. Any employer in the industry is going to laugh at that, but we have to respond to those kinds of requests, and that means extra documentation in these H-1B petitions. So just be aware of that. It's not as easy now as it has been in the past to qualify for H-1B because of that. These positions too, the H-1B jobs or the H-1B visas are limited to a quota or a cap each year. That quota is issued on the government's fiscal year, which starts October 1st and goes through the following September 30th. Every year, it's very competitive for those visas. There are lots more applications than there are visa numbers available. And when that happens, there's a random lottery drawing to select out the people that will actually get those visas. So there are 65,000 regular visas under the cap, and there's an additional 20,000 that are set aside from people that have earned a master's or higher level degree from a U.S. university. So if you do have that master's or higher level degree, which all of you do, you're eligible for both quotas. Also, in addition to that, there are going to be certain types of jobs that are going to be exempt from that quota. So you don't need to worry about the lottery. Those are going to be jobs with any college or university, any kind of position with a nonprofit organization that's affiliated with the university. So teaching hospital, research hospital, anything like that is going to qualify. Also, employees of government research organizations or nonprofits affiliated with a government research organization. So if you're looking at positions like that, any kind of academic position, any kind of teaching position, any kind of hospital research position, those are all going to be exempt from the quota. That means you can apply for H-1B visas anytime during the year. You don't need to worry about the quota. But if you're looking to work for a private employer, any for-profit organization, then you are going to be subject to that cap or quota. The timing for that, so the H-1B is not something you can apply for by yourself. It's something an employer has to do for you. And they do that by filing what's called an H-1B visa petition. It's basically a set of government forms that they send in by mail to the U.S. Citizenship and Immigration Service. The timing for that is 6 months before the quota opens, which means April 1st. The government will accept filings, these H-1B petitions, during the first 5 business days of April. So this year that means April 2nd through April 6th. They'll accept these filings. They usually get about 200,000 or so of these H-1B petitions every year. What they do initially is some minimal data entry. They then sort them into 2 groups. Those who have the master's or higher level degree from a U.S. university, and then everybody else. From that first group, they're going to hold a random lottery and draw out 20,000. When I say random, I really mean random. They don't do any pre-screening to see who has the best application or who's the most qualified. It's completely random. If you get selected in that first lottery, great, the petition is processed. But the earliest that the H-1B status can take effect is October 1st, which is the start of the fiscal year. If you're not selected in that first lottery drawing, your petition automatically goes into the second lottery drawing. And from that, they're going to randomly select out 65,000. Any petitions that are not selected in the lottery will just be returned to the employer. All the paperwork just returned. So it's an incredibly frustrating experience every year for anyone who's trying to get these H-1B visas, because even with a master's degree or a higher level degree from a U.S. university, your chances of being selected in the lottery are under 50%. So it's not great, and you can't guarantee that you're going to do it. So those of you who are working with optional practical training under your F1 visa or with a J visa, I encourage you, if you're thinking about changing over to H-1B, to try the lottery as early as you're eligible, because it might take you 2 or 3 tries to get selected, and you don't want to wait until you've used up all of that optional practical training time and then try and find out you didn't get selected in the lottery. So it's always best to try as early as you can. Another thing I want to point out about the H-1B visa is there is a wage requirement with this. The Department of Labor is involved in evaluating these H-1B petitions as well. Employers are required to attest to the Department of Labor that they're going to pay you a competitive salary based on Department of Labor salary surveys for that kind of job in that geographic location where you're going to be working. Those Department of Labor salary surveys are cross-industry, and they're a little bit misleading. So for example, if you're going to be looking at a research organization in Silicon Valley, those jobs are going to be with the for-profit organizations, the pharmaceutical companies and things like that, as well as the university researchers, which might have much lower pay scales. So it's going to be a pretty high wage often for these H-1B petitions that are going to be required that the employer pays. The employer has to file something called a labor condition application with the Department of Labor, which has to be certified by Department of Labor, confirming that the wage that's being offered is appropriate. So if you're thinking about working for a startup company or a newer company like that, just be aware of this wage obligation. It is going to be a problem for a lot of employers to be able to sponsor you for the H-1B because of the wage requirement. A lot of the startup companies like to run kind of lean and mean. They might want you to work for some sweat equity and not want to pay you a very high salary, but that's not going to be feasible under these H-1B requirements. We're also seeing this year, under the Trump administration, an even greater scrutiny on this wage component. The Department of Labor salary surveys have kind of 4 levels of wages. So level 1 should be for entry-level positions, people who have just newly graduated or have maybe 1 to 2 years of experience. Level 4 is going to be for your very highly skilled workers, people that exercise independent judgment, maybe have some supervisory responsibilities, etc. And 2 or 3 are going to be those intermediate wages. We're seeing a lot of pushback on the level 1 H-1Bs this year, wages, from the Trump administration. They're basically, again, challenging whether or not that's really a specialty occupation if the employer is only paying the lowest level of the salary survey. So again, this bumps up the salary requirements for these H-1Bs for private employers, and it does make it out of reach for a lot of these positions, especially with startup companies. So just be aware of that when you're looking around for positions. It's going to be tough, and you want to make sure that that salary offer is going to be competitive enough to qualify for H-1B. Another thing to be aware of with the H-1B is there is a certification requirement under the Export Administration regulations. The U.S. regulates the kind of technologies that can be exported to certain countries. And even though hiring you is not exporting technology, under this regulation, it's considered a deemed export just by exposing you to certain technologies. And these technologies are pretty much very broad. So any kind of computer technology, any kind of biotechnical technology, bioinformatics, they're all going to be included in this category. And so if you are from a country that is regulated under the technology export regulations, this requires an extra certification from the Department of State, and it can slow down your ability to get H-1B status. You've got to have a license from the employer, or they have to demonstrate that you are going to be excluded from certain technology or knowledge of certain technology while you're doing your job. So just be aware of that. It depends on what country you're from, whether or not you're going to be subject to that, but it can often mean a 3 or 4 month delay waiting to get this license in order to qualify for H-1B, and if that applies. As I mentioned, there's quite a bit of forms that are required for this. The employers got to do that. They should also be paying the law firm or attorney, if there is one, preparing this paperwork. The employer should not be asking you to pay for that. That's not allowed under the regulations. So if the employer is asking you to reimburse them for any of the legal costs or the filing fees that go along with these visa petitions, that should be a red flag for you, and it's something that you want to have a conversation with the employer about. We have seen a much higher increase in site visits and audits on these cases where the U.S. Citizenship and Immigration Service is actually coming out to the work site and interviewing employees and wanting to know who paid the fees and whether or not you're being paid the proper salary and exactly what you're doing, and making sure that the business is really is as it is described in the paperwork. So you definitely want to make sure that the employer is not trying to cut any corners here. If you are going to be employed in H-1B status, you want to make sure that they're following all of the regulations to the letter, because we are seeing quite a few of the site visits. Probably 35% of employers will have a site visit this year. The filing fees for these H-1Bs are expensive. The base fee is $460. There's an additional $500 fee, which is supposed to go into a fraud detection fee. That's what pays for all those site visits. And then there's an additional fee. It's called a training fee. It's supposed to go into a pool of money to train American workers to do highly skilled work. I don't think it's actually used for that, but it's supposed to be. That training fee depends on the size of the employer. So the small employers, 25 or fewer employees, it's going to be $750. For those with 25 or more employees, it's $1,500. So you can see those filing fees add up to over $2,000 for this try on this H-1B petition. So that, on top of the legal fees, it's usually over $5,000 for the employer to try one of these H-1B petitions for you. And even if they try, they don't know for sure that it's going to be accepted under the lottery. So just keep that in mind. Some employers are going to balk at this. So even though you've got a great job offer and they're interested in hiring you, when they find out that you might need an H-1B petition, they might be a little bit nervous about doing that. So go ahead.
So if you have already like an H-1B in a non-profit, you cannot transfer it, right?
You can transfer an H-1B from a nonprofit, so that you have to be CAP exempt H-1B. You can transfer it to a private employer, but you're going to be subject to the quota. So you're going to be limited to that April-October timeframe. And the start date at that new private employer can't be before October 1st.
But it can be transferred. The H-1B can, from non-profit to profit, can be transferred?
It can only be transferred if you get selected under the lottery. You have to have one of those CAP numbers. The one exception to that is if you're working concurrently for a CAP exempt employer, like a university, and also at a private for-profit employer. If you're working both jobs and you have concurrent employment at both, that requires each employer to file a separate H-1B petition for you. But as long as you don't give up the exempt job, you can also work for a private employer at the same time. So that's the one exception. You just, if at any point you stop working for the CAP exempt employer, you're going to lose the H-1B petition for the private employer.
So what about if you transfer from this university to another one?
That's fine. You can absolutely report to another CAP exempt position anytime during the year. You don't have to worry about this April, October business. So the H-1B status can be valid for up to 3 years initially. It can be extended for a total of 6 years. Once you have H-1B status, if it's subject to the quota and you've been counted against that quota the first time, you can transfer to any employer without worrying about quota again within that 6-year period. So you only have to be selected in the lottery that first time. Once you have that lottery number, you can transfer. You can transfer employers as many times as you want to, and you don't need to worry about the April, October timing business. You can do it anytime during the year. To do the transfer, the new employer has to file an H-1B petition with the U.S. Citizenship and Immigration Service. It includes all that paperwork, including the certified labor condition application from the Department of Labor. That takes about 2 to 3 weeks to prepare that paperwork and get it filed. But once it's filed, you can start work at the new employer even before it's approved by U.S. Citizenship and Immigration Service. So for that first H-1B petition that's subject to the quota, you have to be selected under the lottery. It's got to be approved before you can start work, and the earliest it can start is October 1st. But after that, you can change jobs as many times as you want. The paperwork just has to be properly filed. Okay?
For the transfer, is the new employer supposed to also pay the $5,000?
Yes.
So
Yes,
it's
the
not
new employer.
essentially just a transfer.
No, it's not. It's like a new petition, essentially. The only difference is you can start work upon the filing rather than waiting for it to be approved. But yes, it's the same paperwork that they have to file again, all of the same fees. Correct. The H-1B status, you get a total of 6 years. And that only counts the time that you're actually physically in the U.S. and in H-1B status. So you might have an H-1B petition that's approved for 3 years, but you might not activate it right away. And if you don't, you're not losing time by doing that. So it is only going to count when you're actually working in H-1B status. And any time you spend outside the U.S. during that period doesn't count. So let's say you go back home to visit your family for 3 weeks. Those 3 weeks out of the country don't count toward your 6-year limit. So once you are in H-1B status, you want to keep track of the days that you spend outside the U.S. so that you can recapture those. Each time you transfer to a new employer, they can ask for up to 3 years on that transfer. So they can extend your stay for up to 3 years at the time of that transfer. And you can continue extending in 3-year increments until you hit the full 6 years. So it doesn't matter even if you transfer jobs 20 times, you still get the full 6 years. Okay? There's certain exceptions to that 6-year rule. If you are in the process of applying for permanent residence, there are certain exceptions where you can extend your H-1B status longer than 6 years. And I'll get to that in a minute. That 6-year limit applies whether you're working for a CAP exempt or a CAP subject H-1B employer. So it doesn't matter. You start out working for a university and then later you change to a private employer and are subject to the quota. The entire period that you worked at both employers is going to count toward that 6-year limit. For people that are applying for permanent residence, there's sort of 2 ways that you can extend H-1B status beyond the normal 6-year limit. The first rule says that if your employer files the first application in towards a permanent residence application, whatever that might be, at least 1 year before you hit your 6-year limit, so by year 5, then you can extend H-1B status in 1-year increments until there's a final decision on the entire process of your permanent residence application. Okay? The second rule says that if you get through the first 2 stages of a permanent residence application process, and I'm going to explain what that means a little bit later when we go into the permanent residence process. And the only reason you can't finish out your green card is because of the per country limitations. There is a quota on the number of people that can be granted permanent residence each year, and those quotas are based on the category you're applying under as well as your country of birth. Certain countries of birth are going to have longer waits than others. I bet you're from India, right? India has the longest wait. India and China have the longest wait. So it might take 7 to 10 years for somebody born in India to get permanent residence status because of the per country limitations. And when that's the case, then the second rule says, if you're just waiting because of the quotas, you can extend H-1B status in 3 increments for as long as it takes until that quota number is current. That's true regardless of whether you change employers with permanent residence. So let's say you get through the first 2 stages of the permanent residence process, and then you decide to change employers. That locks in that ability to continue to extend H-1B status. So even though you've got to start the process over with a new employer, you're not going to lose that ability to extend your H-1B status. Concurrent employment, you cannot have 2 different visa statuses at the same time. So for example, you can't have F1 and H-1B at the same time, but you can work 2 jobs with 2 of the same type of visa. So for example, if you are an F1 OPT, you could have 2 concurrent jobs. Both of them have to be under the F1 OPT. Same is true with H-1B. You can have 2 concurrent jobs or more under H-1B. It's just that both employers have to file that H-1B petition for you. I'm going to talk now. Does anybody have any questions about H-1B status? That's all kind of all I was going to mention.
I'm on the F1. So I'm on the F1, but I want to start the process for applying to
H-1B?
no, permanent residence.
Permanent residence.
How do I, because I need to reapply for my OPT once it expires. I have 1 year first, and I have 2 years. How do I, should I wait until I apply for the extension before I go on with the permanent residency, or what's your advice?
So I'm going to go into the detailed process of applying for permanent residency in a minute. But in general, applying for permanent residency is not fast. It takes most people at least 1.5 years to complete that process. F1 is not a great platform to be applying for. And the reason is, the non-immigrant or temporary visas are kind of divided into 2 groups. One group are what we call non-immigrant intent visas. The other group are what we call dual intent visas. The non-immigrant intent visas require you to maintain a permanent home back in your home country. Be coming here just to complete your school program and your period of practical training, and then to have an intention to go back to your home country. They're not really compatible with applying for permanent residence. And if you try to travel with your F1 visa in the middle of a permanent residence process, when you come back into the country, the immigration inspectors at the airport are required to ask you 2 questions. The first one is, what's the reason for this trip? And the second one is, how long do you intend to stay? If you answer that second question, oh, I'm applying for permanent residence, they should refuse your admission. Okay? Now, we all know that the immigration inspectors at the airport are not perfect, and they don't always ask you that question. You know, sometimes they look at your paperwork and they're like, oh, you're coming back for UCSF, welcome back. And they don't even ask you that question. Okay? But the USCIS that's adjudicating your application for permanent residence is going to look at those travel dates, and it's going to look at when you started applying for permanent residence, and when they get around to adjudicating your application, they're going to assume that you must have lied to that immigration inspector, otherwise he shouldn't have brought you in. So it's risky to apply from F or J, which is also a non-immigrant intent visa, to directly to permanent residence. It doesn't mean you can't ever do it. There are certain circumstances where it might be appropriate. For example, you came in to do a school program, you really thought you were going to go back to your home country at the end of that program. At the time you applied for that visa, you don't intend to travel outside the United States, but now that you're here and you've finished, and you've got some job prospects here, and you realize the job prospects are much better here than they would be if you went back home, and you've changed your mind, That's okay. That's not a misrepresentation if you change your mind after you made that representation. So in certain circumstances, it might be okay to apply for permanent residence, but you've got to realize it's not quick. It might take you a year and a half, and it might be no trouble to go back home to visit during that process, okay? You also might run out of employment authorization during that process, depending on what you qualify for.
So can I go to H4?
That would be better. That would be better. So the H-1B is a dual intent visa. It's designed to be a platform towards permanent residency. So it's completely compatible with applying for permanent residence, and it's a much better platform from which to apply. You'd also make sure that you have work authorization the entire time while you're applying for it, because you've got the full 6 years plus some if you're in the process of applying for permanent residence. So you know you're not going to run out of employment authorization in the middle of the process. So that would be a much better option. Yeah.
So is it easier to apply the petition for 1 year, then extend every year, or just apply for 3 years?
For H-1B?
Yeah.
My recommendation is you apply for 3 years if you're eligible. Certainly, it's more expensive for the employer to do it every year, because they have to pay the filing fees every time they file a petition with it. They ask for 1 year and 3 years. So it's more expensive and more time-consuming for the employers if they do it every year. Sometimes you don't have a choice. You might be in a postdoc position where it's only a 1 year position, and the university's not willing to do it longer than 1 year, and so you might not have a choice, and you might be stuck with that. But whenever it's possible, ask for the maximum period of time, which is going to be 3 years.
The example that you gave where you can have like 2 H1, one on cap exempt and one on non-cap exempt.
Correct.
If I'm working with cap exempt full time, and if I have someone who wants to hire me on non-exempt, do I have to still go through the quota, and I want to maintain both, so do I
You
still
want to
have to
maintain
go
both?
to quota? Yeah.
So you have to have the cap exempt position
Yeah.
first. You have to
Yeah.
be working in that.
Yeah.
And then, yes, you can apply at the same time concurrent employment to work at a cap subject.
Yeah.
You have to be working both jobs at the same time to keep it.
Yeah, but the
Um,
number of hours remains 40, right?
Yeah. You can work more than 40 hours a week if
Yeah.
you're capable of doing that.
Yeah.
They're going to be suspicious if they're both full-time jobs.
Yeah.
But if, one of them is 15 hours a week and the other one's 40 hours a week, that's
Yeah,
going to be fine.
absolutely. And the second question I have is I-140, you said that 3 years, once I-140 is approved, you get like 3 years of extension.
Correct.
Recently, Trump administration proposes change, right? Is it going to be like, what is the wording on that?
Yeah, it's clear the Trump administration does not understand our immigration regulations at all, or even the administrative process of changing regulations. That particular aspect of being able to extend H-1B status in 3-year increments is a statute that was passed by Congress. It's not a regulation that could be changed by the Trump administration. So in order to see a change like that, we have to see an act of Congress. I don't see that happening anytime soon. Congress can't even manage to pass a decent budget. And they're certainly not looking at trying to restrict high-level individuals who are applying for employment-based permanent residence. So I don't see Congress changing that rule. The other rule, the one about the 1-year extensions, the actual it's also a statute, but the wording of it says that USCIS may extend in 1-year increments, whereas the 3-year extension says shall. That word shall means they must. They don't have a choice. That word may means it is more discretionary. So once you're at the I-140 stage, you're safe. Definitely safer than if you're just at the labor certification process.
Thank you.
So after the first 3 years, when you apply for extension, do you again go into lottery system, or
No.
just plain extension?
No, once you've been counted once for the lottery, you're good for the next 6 years. You don't have to worry about it.
Thank you.
For the positions that are exempt from the lottery, does that mean that they can apply for H-1B at any time?
Yes, anytime during the year. You don't have to worry about the lottery. And as long as all the other qualifications are there, you're guaranteed to get it. Yes.
How long does it take to get the cap exempt H-1B?
So the normal processing time right now is about 3 to 4 months. There is a premium processing option, which is an expedite service. It costs an extra fee of $1,225, but if you or the employer want to pay that fee to get a decision sooner, then they guarantee a decision in 15 calendar days or less.
But I heard that last year premium processing was stopped.
Yeah, it was right before the H-1B cap season. What happens is the U.S. Citizenship and Immigration Service tends to get very busy right around this time of the year because they're gearing up for that April 1st crunch of all those H-1B petitions. So they like to clear out their workload of other kinds of H-1B extensions and cap exempt petitions before they get to that April 1st deadline. So they've done that a couple of times in the past where they cut off the premium processing just to make sure that they could clear out that workload in time so that when April 1st rolls around, they would have enough capacity to handle it. This year, it's still going on right now. I don't know if they're going to cut off premium processing for a period of time after around April 1st. We'll have to wait and see.
And does that time include also the thing that you said about certain countries that they need to know about the ITAR or information, like the license, export license and stuff?
Yeah, so the license has to be included.
Can you repeat the question for the?
Yes.
Thank you. It's a little hard to hear.
Sure. He was asking about for people that are subject to the export control licenses, whether or not that timing included that period. No, so the license has to be obtained before the H-1B petition is submitted. So the license would have to be in place before they could even file that paperwork.
Sorry, another follow-up question. So, like, usually universities are subject. I mean, they have to have that as well or not? And,
no, so universities are often exempt from this export control license. So anytime it's kind of research information that's in the public domain, they're going to be exempt from that licensing requirement. It's going to be more for the private employers who have kind of proprietary technology that they want to keep secret.
Sure.
That's usually when you're going to be subject to licensing. The university positions are normally exempt.
Thanks.
Sorry, I heard that they reinstated premium processing for academics. Is that correct or no?
They've reinstated for everybody now. When they sort of reinstated it last year, they kind of did certain groups at a time. And the first one that they opened up was the cap exempt H's, and then they started doing everybody else. Yeah, because it's a smaller pool. Other H-1B questions before I move on to J's? Yeah.
With the premium processing, forgive me if you answered this earlier, does the employer also have to pay that premium processing?
No. That is the one fee that either party could submit the fee. The employer has to request premium processing. It's not something the employee can do by themselves. The employer has to sign a form to request it, but either party could pay the fee. Sometimes it's an advantage for employees to need premium processing because they want to travel or for other reasons, and so the USCIS recognizes that it's not always the employer's desire for premium processing, sometimes it's the employee's need. What we're seeing now too is a lot of employees are nervous under the Trump administration about making sure their H-1B petition is approved. And so they're asking for premium processing just for peace of mind because they don't want to wait 3 or 4 months to find out that it's not going to get approved. I don't think those of you in this room need to worry too much about that. The highly educated, well-paid professionals are not going to have an issue with this. What we're seeing kind of the most pushback are on kind of computer consulting companies. That's really the focus of this kind of crackdown. So, don't go to work for an IT consulting firm and then you'll be fine.
Can I add one more question? Is there any rule added because of the recent travel ban in terms of lottery and these things for H-1B? Is there any nationality ban?
There's not. No. There's not. No, not in any way. Even nationalities that are subject to the travel ban, So if somebody was outside the U.S. and didn't have any connections to the U.S., they might not be able to get an H-1B visa. But those of you who are here, there's no difference in terms of processing. We're not seeing any additional scrutiny. We're not seeing additional delays inside the United States. We are seeing delays for people applying for visas at the consulates abroad, but not inside the U.S. Other H-1B questions? Okay, we're going to move on to J's, just really briefly. So those of you in J status probably already know whether or not you're subject to the rule that says you have to go back to your home country for at least 2 years at the end of your J program before you're eligible for certain types of visas. So the people that are going to be subject are anybody who's in medical school or receiving any kind of advanced medical training, anybody who's received any kind of funding for their J program, either from their own home government or from the U.S. government, and anybody who is getting education in anything, any kind of field that's listed on the skills list that's been negotiated between your country and the United States. So some countries are not going to have anything on their skills list, and some countries are going to have a really big long list, and pretty much everything is included on the skills list. So those are the 3 things that make somebody subject to that 2-year rule. If you're not sure if you're subject, you can look at your DS 2019 form. It should say at the bottom whether or not you're subject. Sometimes too, it'll say on your visa. It'll say either exempt or subject. 212E is the specific section of the Immigration and Nationality Act that includes the 2-year home residence requirement. So if it says subject to 212E, it means you are. If it says not subject, it means you're not. I will note that the State Department, when they're issuing visas at the U.S. embassies, makes a lot of mistakes on whether or not you're subject. So you might see a discrepancy on your DS 2019 versus your visa. Or you might see that your visa says you're subject, but you think you're not, or vice versa. That's always a good thing to have an analysis done by an attorney. Because they do make a lot of mistakes, and that is something you critically want to know, whether or not you're subject to that or not. If you are subject to that rule, it means you cannot apply for H-1B-L visas, which are intra-company transfer visas, and K visas, which are fiancés of United States citizens. You're just not eligible for those visas, whether you apply inside the U.S. or outside the United States. It also means that you cannot change status from within the United States to the O1, which is a temporary work visa for somebody of extraordinary ability, the TN, which is a work visa for Canadians or Mexican professionals, F1, B1, or B2 visas. You can, however, get those visas if you go outside the U.S. and apply for a visa stamp at a U.S. embassy or consulate and then come back in. So it is possible to get that second category of visa. It just means traveling and coming back in. But the H-1B, the L, and the K, or permanent residence, not available if you're subject to that 2-year rule. You can get a waiver of that 2-year home residence requirement in certain circumstances. The easiest one to get is something called a no objection statement. This is where you go back to your own government and you say, look, I'd really like to stay in the U.S. I don't want to come back for the 2 years. Do you have any objection? If your government tells the United States State Department, we don't object, it's okay if they don't come back for the 2 years, you can get that type of waiver. I will note, though, that even if your government agrees to that, the U.S. State Department doesn't necessarily have to agree as well. So there's going to be certain circumstances where your government doesn't object, but the State Department for the United States does object and doesn't grant that waiver. Usually that's when there's some kind of U.S. government funding involved for that J exchange program, or some type of international award where the United States participates in it and thinks it's an important exchange program, like the Rhodes Scholarship Program, for example. If you have any Rhodes Scholarship money, State Department is not going to approve your no objection waiver, okay? Second way you can get a waiver is if you can show that you have a U.S. citizen or permanent resident spouse or child, and that spouse or child would suffer exceptional hardship if you had to go back for 2 years. That's a really difficult one to get because it's really hard to show that you can't be separated from a spouse or child for 2 years without creating exceptional hardship. Usually it's only granted in really extreme medical situations or things like that. Or if the spouse happens to be from a country where there's a lot of danger, like Syria or somewhere like that. But that one is a tough one. You can also get a waiver based on persecution. This is if you have a situation where if you were to return to your home country, you would be persecuted by the government in your home country or a group the government can't control, based on your race, religion, political opinion, one of those reasons. If you qualify for a persecution waiver, you will also qualify for asylum in the United States. And frankly, if I were you, I would just apply directly for asylum and not worry about the J waiver, because asylum gives you the ability to stay in the United States indefinitely. And after 1 year, you can adjust your status to permanent residence to get a green card. So that's going to be a faster way to a green card. So if you qualify for a persecution waiver, just apply for asylum, okay? A third way is interested U.S. government agency. Any U.S. government agency can recommend to the State Department that they grant a waiver because whatever it is you're doing in the United States is important to keep in the United States. So if you're doing some type of research that's of interest to the Department of Defense or the Department of Energy or the Department of Health, and you can get them to attest to the Department of State that that's the case, you could be granted a U.S. government agency waiver. And the final one is for medical school graduates. If you agree to practice medicine, it's got to be a family medicine or psychology, in an underserved area, so that's usually going to be in some rural area for at least 3 years, then you can be granted a waiver into that. There's kind of 2 programs under that. The Conrad waivers are state programs, so there's going to be a certain number of slots per state available. They can also be granted based on a federal government waiver sponsored by the U.S. Health and Human Services. You should also note that your spouse, if you have one and you are subject to the J waiver, your spouse is also going to be subject to that waiver. So if you are a spouse and in J2 status and then you get divorced and your J1 spouse goes home and you want to stay, you're still subject to the waiver even though your J1 spouse went home. So just be aware of that.
Yeah, I want to ask if I receive funds from NSF, would that make me subject to the home residency requirement?
Not necessarily. It depends on what kind of funding that is. Sometimes those are private grants under NSF and not funding for the actual exchange program itself. So it's going to depend on how it was earmarked and how it's allocated on your DS 2019. So you need to take a look at it. Take a look at the bottom portion of your DS 2019 and see if that box saying U.S. government funds is checked off.
So in case that you want to exchange between, for example, J1 to O1, then you need to file 2 forms, one I-129 and another one, or just one?
So if you're subject to the 2-year home residence rule and you want to get into O1 status, then...
So my question is that, well, I don't know if it is 2 forms, or because, for example, if you want to apply for green card, you have 2 forms, I-140 and I-485. I want to see for change from J2 to O1 is also...
Okay, so not subject to the 2-year home residence rule.
Yes.
Okay.
If
It's
you
one form.
Just one form, okay. Okay.
Yeah.
I have a question about the J2. Like, at what point do you apply for the J2? So, for instance, if there's a postdoc who has a 1-year position and then goes home to get their visa stamp, they have their appointment renewed J1 visa, and they go home to both get their visa stamp and also get married, can they apply for the J2 at that point?
Yes.
They have to be, okay, so
yes.
they don't have to wait for all the approval to go forward to oh, so maybe I'll follow up with you after.
Yeah, normally the U.S. Embassy would like to see DS 2019 that mentions a spouse.
Okay.
So an updated DS 2019 that's going to mention a spouse. And then the J2 spouse can apply for the visa at the same time or any time after the J1 spouse applies. So if they apply together, they only need one visa appointment, they can just go in together.
In the cases where someone is getting a no objection statement from their home government, is it almost always supplied or?
Depends on the country. So some countries are really liberal about this, and anyone that asks pretty much gets one. And some are a little tougher about it. It really depends. So the way the process works is you start the application process by applying through the U.S. Department of State, which is the agency that's in charge of the J program. It's an electronic form you fill out, and you send them copies of your DS 2019. Then you go back and you talk to your home country's government, the equivalent of the Department of State, and you say, hey, I would like a no objection waiver. Would you send a notice saying you don't object to the State Department? So they do that directly to the State Department, they don't send it to you. But they're going to tell you, if you go talk to somebody in your embassy, they're going to tell you kind of what the practice is and what they like to see to be able to grant that. And then once the U.S. State Department gets that notice from your home country's government, then they're going to make their assessment. And they'll send you a notice saying, we're going to recommend this waiver or not. And then the final waiver approval actually goes to the U.S. Citizenship and Immigration Service, which is part of Department of Homeland Security. They have final say over whether or not the waiver is granted, but they 99% of the time agree with whatever the State Department recommends.
I remember you said that sometimes there's discrepancy between your DS 2019 and your visa.
Yeah.
Do you mean there is somewhere on the visa that says whether you are subject to the home residency requirement?
Yeah, exactly. So some J1 visas are annotated. It's kind of a little line, kind of right below your picture, that says whether you're subject or not. Not every J visa has that annotation. Depends on the consular officer.
It's actually a question from someone online.
Okay, go ahead.
Yeah, so they ask, after you get a favorable recommendation from the U.S. Department of State, who already sent the recommendation to the U.S. CIS for the J1 waiver, how long does it usually take for the U.S. CIS to issue the waiver from, looks like they're saying Form I-612?
Yeah, so the Form I-612 is the approval notice. It usually takes a couple of months, but you don't have to wait for it. If you want to be applying for a change of status, like change of status to H-1B, you can do that just with a favorable recommendation from the Department of State. So you don't necessarily have to wait for the final approval. Same thing if you're applying for permanent residence. You can start the process of applying for permanent residence just with a favorable recommendation. You don't have to wait for the final approval.
Thanks.
And usually if you do that, let's say you have the favorable recommendation, you apply for a change of status to H-1B. What happens is when the U.S. CIS adjudicates the H-1B petition, they adjudicate the J waiver first and then the H-1B petition. So it actually speeds up the process. Any other J questions?
I do. I think I know the answer to this, but I want to be clear. So the home residency requirement essentially means that you go back to your home country. Okay, there is no way that, so it's not essentially outside of the U.S.
Okay, now it's specifically your home country. So yeah, if you get a great opportunity in Canada or somewhere that you're not from, and you decide to go there for 2 years, that doesn't count. You actually need to go back to your home country.
And is it the country of citizenship, or if you but my partner is from Spain, and like, if we get married, I would probably try to get residence there, a permanent residence. So, but if I wanted to pursue medical education here on a G1 visa, after finishing, would I have to go back to Spain, or would I have to go back to my home?
It depends on
It's
country
just,
of residency.
yeah.
It depends on country of residency, not citizenship. So it depends on what kind of status you have in Spain.
Right.
So if you're in Spain on a temporary visa, it's going to be your original citizenship country that you're going to count as your country of residency. If you have permanent resident status in Spain for your spouse, it's going to be Spain.
Okay.
Yeah.
That's helpful.
Yeah.
Thank you.
Also, you don't have to fulfill that 2-year requirement all at one time. You can do it in little chunks. So you could do like 3 months and then go somewhere else and then do another 3 months. That's okay. But if you do it that way, you want to make sure that you keep really good records to prove where you were and that you have enough days to make that full 2 years.
Thank you.
So if you marry someone who's a J1, and you're also a J1, and you're becoming a J2, the country and come back, or can you?
You can do a change of status inside the U.S. Yeah.
So it's like a new marriage without any like document for you.
Yeah, no, you can do a change. You can do it either way. You can either do a change of status from within the United States, and that's done by filing paperwork to the USCIS, or you could go outside the U.S., apply for the J2 visa, and then re-enter without J2 visa. So either way works. Just be aware that if you do that, if your spouse is subject to the 2-year home residency rule, by becoming a J2 dependent, you're going to own that as well.
If you become a J2, can you have your job still, which was originally at a J1?
Maybe, but you would have to have an employment authorization document to do that. If you're on J2, you have to have an employment authorization document to be able to work. And in order to show that, you have to show that the spouse's work is sort of incidental to the fact that you're here and not a requirement for you to be able to maintain your living expenses here.
What's the maximum duration for J1 stay?
It depends on the category of J1. The J1 is for exchange visitors, and there's a ton of different types.
Okay.
So some people are in student status, some are J1 scholars, some are visiting professors, and it depends on the type.
What's the scholar?
The scholar is usually 5 years.
And you have to always extend it in 1 year increments, or what does it depend on?
No, it depends on the university.
Okay.
So it's usually going to be whatever the grant funding is available for that program, and that's usually how the university is going to decide it. But they can do it for a longer period. They can do the full 5 years if they have the funding.
And the 5 years is in in one period? Like, for example, I've stayed a year in the US on a J1 visa, I don't know, 6 years ago, and now I'm back on J1. So does that already count towards my 5 maximum?
Were they both in the scholar?
I don't know. The one was a student probably, and now it's a
Yeah,
scholar.
so it's going to be different. Yeah, it's going to be in a period under the scholar. Yeah.
And, sorry, changing to an H1B, would you recommend doing that, like, I don't know, after 3 years of J1 to slowly, start the process, or?
Yes, I think it depends on whether you want to stay in academics or whether you're going to go into private employment. If you're going to go into private employment, you want to start early because you're going to be subject to the H1B cap, and you might have to try the lottery a few times. And you don't want to run out of J status before you do that. If you're going to go into academics and you're looking at university positions, then you can have the cap exempt H1B. If you're thinking about permanent residence, like I said, I think H1B is a much better platform to start that, so I would start it sooner rather than later.
Okay.
If not, there isn't any urgency to switch over from J to H.
Okay.
The universities like the J better because it's cheaper and easier for them.
Yeah.
So they're going to try to steer you in that direction.
Okay.
So when I get the recommendation, I can apply for H1
Yes.
from you. But do I have to send the waiver again when I get it?
No.
I do not need to send
No,
the
they
waiver.
do it internally because the H-1B petition goes to the U.S. Citizenship and Immigration Service, and that's where the J waiver is decided as well. So they just pull it from their records internally.
Sorry, I think I missed this. If I apply for a J1, do I have to go back to my home country to get it stamped?
So you're changing status if I'm like F to J, for example?
Yeah, OPT to J1.
Okay. No, you don't. So you can do that change of status inside the United States, as long as the J1 sponsoring organization is okay with that. Okay. So the J1 sponsoring organizations are designated as such by the Department of State. So most universities are going to be qualified to sponsor J1s, but there's other organizations too, like the French American Chamber of Commerce and certain student organizations, etc. They are kind of bound by pretty strict regulations by the Department of State. to make sure that these programs are really fostering the exchange. So Americans are going to whatever countries and vice versa, and then really these people are only going to be here temporarily, and they really are going to take that knowledge and cultural experience back to their home country. Okay. So when somebody is here and they use up 3 years of F1 OPT, and then they want to apply for J1 practical training, they don't like that. And they're not going to be excited about it. So if you're going to be doing something like a scholar program, they would. But if you want practically, a more training period, the J1 trainee, it's unlikely to work.
And so you said that if a person can stay on J1 for 5 years if they're a research scholar, how about the J1 that PCFM supports for physicians?
For physicians, it's going to be through your medical program plus your residency.
Right, so how about the fellowship? Because it can take forever.
Yeah.
10 years there.
Yeah, it'll cover the entire fellowship. Yeah. Yeah.
And it doesn't matter like what you had like J1 before that, like before you go to residency, right? So if suppose like
Yeah, like
you
I've been here for 2
PhD
years
and
on
then
J1,
maybe-
and then I'm gonna switch to PCF and J1,
Mhm.
and this 2 years it doesn't count.
Doesn't count.
Okay.
No. So it's a different J program, so it has different restrictions. Yeah. It's going to be subject to the 2-year rule. Yeah.
So is it subject to the 2-year rule even if you switch? Like
It's
like
subject,
if you're
yes.
Switching.
Yes. Yes. So each individual J program, they make an analysis about whether it's subject. So you could be in a program that was not subject and then change to one that's subject. That means that you are subject to it.
So if you're in a J1 program that is subject to the home residency requirement, if you're switching to a different J program, would you have to fulfill the requirement first before you switched?
No.
Okay.
You can stay in J. It's just that it's going to restrict, if it's subject to the 2-year rule, it's going to restrict your ability to change to any other type of visa status or H-1B, L, K, permanent residence.
There are some postdoc positions available in industry in like for-profit thing, but there are postdoc positions. Which visa category would they fall under?
Could you repeat the question? Yes, he's asking, there are some postdoc positions that are with private industry, and he's asking what kind of visa would be the best for that. It depends on the program. If it is with a nonprofit organization that is affiliated with the university or a government research organization, CAP exempt H-1B is a great option for that. Sometimes the J scholar program will work for that as well. It is really going to depend on the program and the specific organization that is sponsoring it.
Hi, if my spouse has I-140, like she applies to permanent residency through a company and then she gets I-140, and if I want to convert to H4 visa from my J1, so do I still have to go through this waiver process?
Are you subject to the 2-year home residence rule?
Yeah.
So you need to get a waiver first. And then once you have a waiver, you can change status to H4. But you have to get the waiver before you can get any kind of H status.
Yeah, I have a question. You said for the J1 scholar, you have the 5-year time length. And for example, if for the first J1 program, I did it together with UCSF, then after 2 years, like to change a university, then how does this count for? Is the same J1 program subject to 5 years, or it comes separately, or?
Yeah, so it's going to be a total of 5 years. You'll need to transfer your DS 2019 to the new program, and they're going to count that first 2 years. So you don't get 5 years at each institution, unfortunately. But you don't want to do postdoc that long anyway. More Jay questions? Or?
Quick one. Let's say you finish your postdoc and you're searching for a position, but meanwhile you're basically unemployed. Can you stay on a J1, or do you always need to be employed throughout the entire time?
So there is a grace period of 30 days at the end of the J program, so you are allowed to stay for up to 30 days afterwards, but after that, no, you've got to either change to another visa status or leave the country. You could always come back in another J program, you know, once you leave, but can't just hang out. Yeah.
If you want.
Go ahead.
I didn't so if you apply for a short-term scholar, which is a 6 months J1, then you want to reapply again for the postdoc position, which is again a J1. Is there a 2-year bond? Because I know there's a 2-year rule and there's also a 2-year bond in between the J1s. So, and then the J1 you apply for postdoc will be a 1-year J1. Is there like again a 2-year bar in between or not?
No, because it's going to be a different kind of program. So instead of the short-term scholar, it's going to be a longer-term scholar program. So because it's a different type of J exchange program, there's not a kind of limit in between how much you can apply. If you were subject to the 2-year home residency rule, you're still going to be subject to that, even if the new program is not subject. But you shouldn't have to wait 2 years. I will note, though, that the individual J program sponsors, so whether it's a university or another organization, they often have their own internal rules, which might be more strict compared to the general federal regulations. Because they want to make sure that they don't lose their ability to sponsor people. And to do that, they have to show in good faith that they're really trying to foster these exchange programs. So for example, a lot of the programs are going to say you need to go back to your home country at the end of this program, even if you're not subject to the rule. We don't want you changing status to H-1B or anything else in the United States. Sign this contract saying that you promise that you're going to do that. So I've definitely seen a lot of J programs that have that extra requirement. That's not a legal requirement. That is a contract agreement that you made with the J exchange program sponsor.
Say after the 30 days, if you go home after your 30 days post J1, is it okay for you to come back in on ESTA for like business trips or tourist trips over the next year while you're applying for H1B? Say if you hit the end of your J1, you're applying for H1B from home.
So there's nothing in the law that would prevent you from doing that. But it is going to be a discretionary call on the part of the immigration inspectors at the airport whether or not to admit you on ESTA. When you come in on ESTA, you're really coming as a visitor in either in the B1 or B2 category, depending on what the purpose of that trip is. It's just that you don't have to get an actual visa stamp in your passport. But you still have to meet the requirements for that B1 or B2. And that means showing you've got a permanent home back in your home country, that whatever it is you're coming into is consistent with a brief and temporary trip that doesn't involve working, and that when you finish with that trip, you're going to go back to your home country. So if you've spent, 6 years in J status in the United States, you go home for 2 weeks and you want to come right back on ESTA, they're going to question that. They're going to wonder what you're doing. You just spent 6 years in J status, you did your 30-day grace period, and now here you are back 2 weeks later. What's going on? It's going to look like you're coming back to just resume living in the United States. So you've got to have some really good reasons on why you're doing this. If you're coming back for a specific job interview and you can show them, look, I've got an appointment for a job interview, I understand I can't work until I get some type of work authorized visa, I'm just coming for this 1 week for this interview, they'll generally let you in. But if you're just coming in to say, hey, I'm going to look for jobs, I'm going to hang out, they generally won't.
Can we please move on to green card?
I'm sorry, I didn't hear.
Can we please move on to green card?
Okay, yeah.
Actually, there was one more question
One more,
about this,
Jay?
if you don't,
Okay.
or I think it is. Someone asked, how do nationals of Iran who are part of the recent ban, how are they treated in general under the new USCIS directives if they're here under a postdoc status?
We've not seen any changes at all at USCIS. The one area where we do see some delays for anybody from Iran is in permanent residence application process, but that's not really new. We've always seen delays with the permanent residence applications. So the average processing time for the end stage of a permanent residence process might be 8 months. For someone from Iran, it might be 2 years, 3 years. They definitely do some extra security background checks, and there's a lot of delays at that stage. But for other kinds of visa applications, H-1B, all of the others, we don't see that kind of delay, and we don't see delays in the early stages of green card applications as well. All right, we will move ahead. I am just really quickly going to mention some of the treaty non-immigrant visas, because I think sometimes people are not aware that these are available, and I want to make sure that you're just aware of them. First one is an E3 visa for Australians. You have to be a national of Australia to qualify for this. It's under a treaty between the U.S. and Australia. It's really similar to the H-1B visa. It's for someone to work for a U.S. employer in a specialty occupation. There is a quota number for it, but we've never hit the quota. So these visas are available all year round. So if you are a national of Australia, just keep this in mind. This is a really good outlet for you, not worrying about the H-1B quota. Also the H-1B1. So this is a subcategory of the H-1B visa. It's very similar to the H-1B visa, except it's a 2-year visa, not a 3-year visa. And it's only for nationals of Chile and Singapore. And again, it's going to be under treaty agreements with those countries. And you might ask, why Chile and Singapore? Well, those countries got on the ball and they negotiated a treaty with the U.S. for these visas. That's why. So you might want to talk to your home country government about negotiating these treaties, because it's really nice. Again, there is a quota on these visas, but we've never hit it. So these visas are available all year round as well, if you happen to be from Chile or Singapore. Also the E2 visa. This is also a treaty visa, so it's not available to everyone. You have to be from a country that has a treaty with the U.S., but there are a lot of countries that have treaties with the U.S. for this. This is a visa for somebody who wants to start a new business in the U.S. or buy an existing business in the U.S. So it's really great for those of you who want to do the startups. It does involve investing some money into that business. It doesn't have to be a huge amount. $30,000 might be enough of a personal investment to do that. It doesn't have to be your personal money. It could be gifted to you by your parents or loaned to you in some way, as long as it's a personal loan. This is a really nice visa. It can be granted in up to 5-year increments indefinitely. There's no limit on the number of times you can extend it. This is not permanent residence, but it's the next best thing if you are an entrepreneur that wants to own your own business. I have clients who've been here 30, 40 years on these E2 visas. They just renew it every 5 years. So keep that in mind. Also the TN visa. This is under the NAFTA treaty. It's only for Canadian Mexican professionals. So if you happen to be Canadian or Mexican, just keep that in mind. You have to be working in an occupation that's listed in the NAFTA treaty, so not every single occupation is in there, but most scientists are in there, as well as all engineers, including software. And finally, the O1 visa. This is for people of extraordinary ability in science, arts, business, or education. This is for somebody who's going to risen to the top of their field and has a national or international reputation in that field. To qualify, there's sort of 2 ways to do it. One is to show you are the recipient of a major international award. When I say major, I mean really major. Olympic medal, Pulitzer Prize, Nobel Prize, something like that. Probably none of you have that yet. The other way to qualify is to show some evidence in at least 3 of these listed criteria here, and then to show that that evidence as a whole tends to show you have that national or international reputation. The O1 standard is not that high. A lot of you from UCSF are going to qualify for this. It does require an employer sponsor, so it's not something you can apply for by yourself. But it is something to think about, especially if you are subject to that J1 2-year home residence rule and are not eligible for the H-1B. You are eligible for the O1, so just keep that in mind. One issue with the O1, it's available for 3 years initially, and then you can only extend it in 1-year increments. So after that first 3 years, it becomes a pain because you've got to do a renewal every year.
Sorry, one quick question. Is this one also has the export license, or
no?
Oh,
Just the H-1B.
Okay, and it works for all companies and also university, and it's transferable.
Yes, the new employer has to file a new O1 petition for you. But yes, there's no annual quota for these visas, so you can apply anytime during the year. Anytime you want to change jobs, the new employer has to file a new petition. It is not like the H-1B where the paperwork just has to be filed and then you can start work. For the O-1, it's got to be approved before you can start work.
And it has premium processing?
It has premium processing.
And VT, does it take more than 2-3 weeks or?
Premium processing is 15 days or less.
Okay.
I will note though that preparing the H-1B petition takes some time. Okay, there's a lot of documentation you've got to prepare to get it ready to demonstrate that eligibility. So usually the time it takes is on that front end, not on the processing time.
Sorry, one just follow-up question. So if you are an OPT, for example, your OPT is finishing, either you have a STEM extension or not, and then you can apply for this during that 60 days grace period or not?
You can.
You can. And also, when is it the day approved? Is the day that you start, you can start work, or you have to wait for an EAD card?
No, there's no EAD. As soon as the petition is approved, you can start work.
Okay.
You can file the petition even though the last day of your 60-day grace period, as long as it's on file, you can stay in the U.S. waiting for the decision, but you can't start work until it's approved.
Okay.
So how hard is to get this kind of visa?
It's super discretionary. So the adjudicators at the immigration office that review these, and there's a permanent residence category that's really similar to this, with the same criteria. The examiners that look at this don't have any scientific background whatsoever. Okay, most of them have a bachelor's degree in history or political science or something completely unrelated. They don't know anything about the scientific process. They don't know anything about the publication process. They don't know anything about the peer review process. So a lot of this is sort of just presenting enough of an education to the examiner to show them why you merit this. A lot of it depends on how well that's put together. They also are going to look at kind of the prestige of the employer who's sponsoring you. So, you know, if you're applying at UCSF, you're going to have a better chance than if you're applying with some startup company that nobody's ever heard of. So that makes a difference as well. And then the evidence itself makes a big difference. It is super subjective. A lot of these criteria are kind of vague. And, you know, what does national or international reputation mean? A lot of this is really going to depend on letters of endorsement from other experts in the field who can talk about your accomplishments and what they mean and why they're important. So if you get a letter from a Nobel Prize winner, even though you don't have a Nobel Prize, but that Nobel Prize winner thinks that you've done some really good work and have the perspective to really benefit the United States, then you've got a really good chance. I will say, coming straight off OPT, it is a little difficult to get these L1s because they're going to view you as a trainee and not an expert in the field. So it can be more challenging to go straight from OPT to O1, depending on what you've done. They're going to look at your accomplishments compared to peer scientists in the field, not to other students or postdocs. So if you won some terrific scholarship, they're not going to count that. That shows you were a really good student. It doesn't show you're a really good scientist. They're really looking for things that other peer scientists would have, other kinds of awards that they might have. So that really matters. Even if you were a top student, they don't care.
Can it be self-petitioned?
The O1, no. The O1 has to be sponsored by an employer. The exception to that is if you're working in a field that typically has short assignments, like you're an actor or a model and you know it's gig assignments, then you can have an agent sponsor you. But for researchers, you've got to have an employer.
And what is it, like is O1 dual intentional?
The O1.
Dual intentional like H1B?
The O1 is right in the middle of that category. It's not exactly non-immigrant intent, but it's not exactly dual intent. It does not require you to maintain a home address the whole time you're in the United States, but it does require you to have an intention to go back. So it is an okay, but it's not as ideal as H1B or L. All right. There's a second type of O1 visa for artists and people in the television or motion picture industry. I don't think we have anybody like that in this room, so I won't go into detail, but just keep that in mind in case you have a spouse who is. All right. We're going to talk a little bit about permanent residence. The U.S. limits the number of people that can be granted permanent residence every year. So there is an annual quota of 226,000, but only 140 of those are going to employment-based options. There's really 4 ways that people can apply affirmatively for permanent residence. The first way, and the one with the highest quota, is for people that are being sponsored by a U.S. citizen or permanent resident family member. Okay, so if you have a U.S. citizen or permanent resident family member, that is definitely going to be the fastest way in most cases. The kinds of family members that work for that are going to be spouses, adult children, parents, and brothers and sisters. The brother and sister has to be a U.S. citizen. Second way you can apply for permanent residence is the diversity visa lottery. This is a random drawing where the U.S. gives away 50,000 visas every year to people that are born in countries that have a low immigration rate to the U.S. So each year the mix of countries that are allowed to apply, it's based on country of birth, not country of citizenship, is going to vary depending on last year's immigration rate. So if you're from India, China, Mexico, Canada, that have high immigration rates to the U.S., you're not going to be eligible for the lottery. But if you're from some other country, you might be. The entry period is in October for 30 days. And it just requires doing an online application form. There's no fee. So to be qualified for it, you just have to be born in one of the countries that's eligible, and you have to have at least a high school education, which you all do. So it's quite easy, and it's free, so there's no downside to trying. You know, chances of winning are not terrific. They usually get between 12 and 15 million entries every year. But your chances are higher than they are in any money lottery that I know. Every year I have clients who win. Last year I had 4 clients who won. I don't know anybody who's ever won a money lottery. So certainly it's worth trying because it doesn't cost anything and there's no downside to doing it. Third way is asylum or refugee status. To qualify in that category, and those are the same thing, by the way, it just depends on where you are at the time you apply. If you're inside the United States, you apply for asylum. If you're outside the United States, you apply for refugee status. But it means the same thing. It's for people that have either previously been persecuted by their government in their home country or a group the government can't control, or who have a reasonable fear that they will be persecuted if they go back, based on race, religion, nationality, political opinion, or membership in a particular social group. So if you think you might qualify for asylum, it's definitely worth looking into. Those applications are confidential. They're handled by the U.S. Citizenship Immigration Service in a separate office that's confidential. You can apply affirmatively. You get an interview process. It's supposed to be a non-adversarial interview. And if you are granted asylum 1 year later, you can adjust your status to permanent residence. So definitely a way to go if you're in that situation. And the final way, which is going to apply to most of you, is going to be through employment. In the employment-based immigration, there are 5 different preference categories. Each of those preference categories has certain eligibility requirements you have to meet to show that you're qualified. And there's also going to be an annual quota limit on the number of people that can be granted permanent residence in that category each year. In addition to the category quotas, there's also that per country quota that I mentioned. So each country of nationality can only use up to 7% of the overall quota for that category. So if you're from India or China, you're going to hit that quota in pretty much all the employment-based case quotas. If you're from anywhere else, those quotas are not looking too bad right now. And I should mention that the quotas, the per country quota, is based on country of birth, not country of citizenship. So if you're an Indian citizen but you happen to be born in Kenya, that's good. Also, if you are married and your spouse was born in a different country than you are, you can choose which country of chargeability that you want to apply under, even if you are the principal applicant. So if you are not married and your parents are arranging a marriage, you might want to think about having them choose someone who was born in a country other than India. So we're going to kind of run through some of these. I'm going to skip a couple of these. The EB-5, EB, by the way, just stands for employment-based. And then the number is the category. So the official names of these are employment-based first preference category, employment-based second preference category, but they're abbreviated EB1, EB2, et cetera. Okay, so don't get these confused with the temporary visas, which are also labeled with letters. These EB categories are permanent residence categories. So EB5 are $1 million investors. These are people that have at least $1 million of personal investment money that they're going to invest in a new business in the U.S. that creates at least 10 jobs for American workers. Most of you are probably not in that category. If you happen to be, let me know.
We haven't quite negotiated the salary.
EB4 is religious workers. These are people that are coming to work in a religious capacity in the United States full time. So priests, rabbis, monks, nuns, imams, that kind of thing. Doesn't apply to most of you in this room. EB3 is for professionals and skilled workers. These are people that are coming to work for a U.S. employer in a full-time permanent job, and who the job itself has to require at least a bachelor's level education or 2 years of skilled training or experience. So all of you probably qualify for that one, but you probably also qualify for EB2, which is for professionals with an advanced degree. Advanced degree here means master's or higher level degree. Does not have to be from a U.S. university. And EB1 is for 3 subcategories: people of extraordinary ability, multinational managers and executives, and outstanding researchers and professors. And we're going to go through each of these in turn. All right. The mainline way that most employees in the United States apply for permanent residence is under EB2 or EB3. So remember, EB2 is professionals with an advanced degree, EB3 professionals and skilled workers. This application process involves 3 steps. It is not something you can do by yourself, except for one exception, which I'll mention later. It requires an employer sponsor. The employer has to do step 1 and step 2 for you, so not something you can drive yourself. It's got to be something the employer agrees to do. Step 1 is something called a labor certification application, and it's filed with the U.S. Department of Labor. You'll sometimes hear that referred to as a PERM application. PERM is an acronym, stands for Permanent Electronic Resource Management System. Doesn't stand for permanent residence. That is just the electronic filing system that the Department of Labor uses to accept these applications. So PERM application, labor certification application, those are the same thing. This is a giant pain in the rear end for most employers. Most employers hate going through this process, and it's kind of a ridiculous process. It was developed by the Department of Labor regulations back in the 1950s. It really has not been updated as much as we would like to see. Some of it is a little bit crazy. But basically, what the employer has to do in order to file this application is to demonstrate that there's a shortage of American workers who have the right education and skill set and are available to do this job in this geographic location. Okay? What that means is the employer has to first define what are the absolute minimum requirements I would need for someone to be competent to do this job. Okay? This is the opposite of what an employer would really do if they were looking to fill a job. Nobody goes out to look for the least qualified candidate, right? Everybody wants the best and the brightest. But this process requires the employer to define who's the absolute least qualified person I could possibly get away with, okay? And define what that looks like. Does that mean master's degree, PhD degree? How many years of work experience? What kinds of special skills in certain technologies or things like that might be required? That's all got to be defined. Once the employer defines that, they then have to place some test recruitment ads in different media sources. They're required to do 2 Sunday newspaper ads, even though nobody looks in the Sunday newspaper before the jobs. The newspapers in the Bay Area figured this out. They now charge exorbitant rates for these newspaper ads. It's about $1,000 to run an ad in the St. Mercury News. Because the only ones who are using it are people having to go through this process. They also have to do a 30-day job listing with the state labor office. That's where people collecting unemployment insurance would go to look for jobs. Not a lot of unemployed scientists out there. Nobody's going to look there. They have to do an internal posting at the work site to let other employees at the work site know that they're doing this process. And they have to choose 3 other forms of recruitment. They have to be different media sources. So for that, they can do things like going through a career fair or college campus recruiting, radio or television ad, advertising in a professional journal, advertising on their website, advertising on another internet or job site like monster.com, things like that. They've got to choose 3. These ads all have to run for 30 days. Then there's a mandatory 30-day wait period. If anybody responds to the ads, even if you're already working in the job in OPT or H-1B or some other non-immigrant status, the employer has to pretend like this is a job that's open and go through their normal interview process. They only have to consider American workers. So that means somebody who has permanent work authorization in the U.S. and is not here on any kind of visa, U.S. citizen or permanent resident. If they find even one qualified American worker, so that means somebody who meets those minimum requirements we've laid out, even if that person is not as near as qualified as you are, that stops the process right there. You can't go forward. So this only works if the employer can go through all of this advertising and not find a single qualified American worker. Generally speaking, it's relatively easy to do this for high-level positions. Pretty much any IT position in Silicon Valley will qualify for this because there really is a shortage. Same thing is going to be true in a lot of the scientific fields. Chemistry, a lot of the private industry fields are not going to have any issues going through this. They're not going to find qualified workers because the majority of graduates from graduate schools in the United States are foreign nationals, so they don't have enough people qualified. So usually it's not a problem, it's just a pain. It's expensive and it's a pain to have to go through all these resumes and to detail all that information. There is a special type of labor certification for academic positions. So if you're going into a teaching position, it has to be teaching, not research, and are looking at a tenure track teaching position with the university and you get selected, instead of choosing the minimum qualified applicant like they have to do for most jobs, the universities get to use their competitive recruitment that they use to select you. And as long as the labor certification application is filed within 18 months of your hire, they can use that recruitment they used to select you and not redo this recruitment under this process. So just keep that in mind. That's called the special handling labor certification. Assuming the employer can get through all this recruitment, not find a single qualified worker, then they file the application electronically with the Department of Labor. Right now it's taking about 4 to 8 months for them to process it and approve it. So we've got that front end of the recruitment process, which usually takes 3 or 4 months, another 4 to 8 months for the processing at the Department of Labor. So this process takes at least a year in most cases, sometimes longer, depending on how efficient the employer is in managing this. But it's not a speedy process, and it's not what employers like to do. They want to make sure, most employers are not going to do this unless you've been on the job for a while and they really love you and they don't want to lose you. But most employers are not going to be excited about doing this from the beginning. Also, the regulations from the Department of Labor require the employer to pay the cost for this. They have to pay all of the advertising costs, they have to pay all of the legal costs if there is an attorney involved, and you cannot reimburse them. So that is another requirement, it is another drawback, and it's a reason why some employers are going to balk at this. If you can get through that first step, that's step 1. Then step 2 is relatively straightforward. It's called an immigrant petition for alien worker. It's filed on form number I-140. It's really similar to an H-1B petition. It's a set of government forms that they fill out. They attach the approved labor certification, and they have to attach proof that they have the financial ability to be able to pay you the salary that the Department of Labor determined was appropriate for that job using their salary surveys. So that is going to be a problem for some startup companies. Some startup companies that are running on venture capital are not going to be able to show that financial piece of it. So just keep that in mind. If you're looking at private industry, you want to make sure it's a well-financed company before you jump into this process. Otherwise, you might get partway through it and realize, oh no, we don't have enough finances to qualify for the I-140. Okay? And then the final step of the process, there's an option. If you're inside the U.S. and working with one of the temporary visas, you can apply to adjust your status to permanent residence. That's done by filing Form I-485. It's referred to it as an application to adjust status or an adjustment application. That's a legal term. That specifically means going from a non-immigrant or temporary visa to permanent residence. It's not the same as changing status, even though that sounds like it should mean the same thing, it doesn't. Change of status means going from one non-immigrant classification to another. Adjustment means going to permanent residence. So one way to do that is to apply through that form I-485, bunch of biographic forms you've got to fill out. They need a copy of your birth certificate. You need to have a medical examination done by an approved doctor to show you don't have any communicable diseases of public health significance. So they're looking for things like Ebola, tuberculosis, things like that, and that your vaccinations are up to date. You have to show that you've been maintaining lawful status the entire time you're in the U.S. So you're going to want copies of all of your immigration status paperwork, so don't throw any of that away. You want to make sure you keep all of your I-20s, your DS-2019s, everything, copies of all your old passports. And all of that is filed by mail with the U.S. Citizenship and Immigration Service. At the same time you file that application, you can also file an application for an interim work permit. It's called an Employment Authorization Document, or EAD card. It's exactly like the one that you have for OPT, except it's unrestricted. You can work for any employer or be self-employed with that card. You can also apply for an interim travel document at this stage. Travel document is called advanced parole. Don't ask me why it's called parole. It has nothing to do with criminal parole. Advanced parole is issued either in combination with your EAD card, so you might get an EAD card that just has a travel notation on it. You probably notice that your OPT EAD has a notation that says it's not valid for travel. The one with this application will say it is valid for travel. If you have that card, or the other way they issue it is a separate document called an advanced parole document that's valid for 1 year. You can travel outside the U.S. and re-enter just with that card or document and your passport. You don't need a visa or any other travel document. The application to adjust status usually takes about 90 days to get that work and travel permit. And then once you have them, you can renew them if you need to, for as long as it takes until there's a final decision. Okay. We're going to talk a little bit about some of the categories that are exempt from the labor certification process. Okay, that labor certification process that I just described is a pain. That is step one for everybody in EB1, EB2, and EB3 categories, with the one exception in EB2, and everybody in EB1 is exempt from that process. So for that reason, it's really nice to qualify in the EB1 or EB2 national interest waiver categories, because that's exempt from that labor certification. It's a faster process and it's easier for employers.
So I wasn't sure if you were going to talk about the applying through a spouse or a U.S. citizen. I had a quick question about.
I am.
Oh, you are. Oh, okay.
I am. I'm going to get to that very end after I do employment.
Okay.
Yeah. So these categories in EB1 and EB2 that are exempt from the labor certification requirement. There's three subcomponents in EB1. The first one is people of extraordinary ability in science, arts, business, or athletics, or education. This category is really similar to the O1 visa we talked about. It's the same criteria standards, either the major international award like the Nobel Prize, or evidence in three of the other evidentiary categories that tends to show that you're a person who has a national or international reputation for being in the top few percent in your field. The difference between the O1 and the EB1 permanent residence category is how they apply that standard. So even though the criteria are exactly the same, it's easier to get an O1 than it is to get permanent residence approved. They just are a little bit tougher on the permanent residence side. You have to be a little bit more extraordinary to be granted permanent residence. So even if you have an O1, it doesn't necessarily mean that you're automatically going to be granted the EB1 category. The nice thing about the extraordinary ability category is you can either have an employer sponsor or you can sponsor yourself. So this is one of the categories that you can sponsor yourself in, and that makes it really attractive. But it's difficult to qualify in that category. And most postdocs are probably not quite there. They haven't quite developed that reputation to do that unless you made some really important discovery and you publish that paper in Science or Nature, it's really tough to qualify as a postdoc. Not impossible. Certainly happens, but not super high likelihood. The next category that qualifies in EB1 is outstanding researchers and professors. So these are people that have a full-time permanent job offer at either a university or a private research institute that has at least 3 other full-time researchers on staff. This one you cannot sponsor yourself. This one requires the employer to sponsor you, but it's a lot less onerous for the employer to do that compared to the labor certification process. Basically, they just have to file the I-140 petition for you, and with that, we have to submit some evidence showing you're outstanding. Outstanding is a lower standard compared to extraordinary. It's kind of similar, and they're kind of vague terms, but it's a little bit easier to meet that outstanding category. And most of you will. If you have an academic position that is an ongoing academic position, not a limited postdoc position that has an end date, it's got to be an ongoing employment. But if you have like an associate research position or something like that, most of you will qualify in this category. You have to show evidence in 2 of 6 criteria for this one, and you have to show that you're outstanding. So not that national or international reputation, just showing you're outstanding compared to others in the field. The third category in EB1 is the international executive and managers. It's really not going to apply to most of you, but it might to your spouses, so I'm going to mention it. These are for people that have worked for at least 1 year in the last 3 years for a company outside the U.S. as a manager or executive, and then are transferred to work for a related company in the U.S. as a manager or executive. When I say related company, I mean the company in the U.S. and the company overseas are either related as parent subsidiary or affiliates. An affiliate are 2 companies that are owned by the same person, group of people, or parent company. Okay? So if you qualify under that, that's a really easy category to qualify for, and it's fast. The final category in this group is the national interest waiver. So this is a little subcategory in the EB2, which is for professionals with advanced degree. So most people applying in the EB2 category require that job offer from an employer and have to go through that labor certification process with the Department of Labor. The exception is for people who qualify for a national interest waiver. What that waiver waives are 2 things. It waives the requirement to have an employer sponsor, so if you get the waiver you can sponsor yourself. And it also waives the requirement to go through that labor certification. So if you get the waiver, you can skip that whole first step and go straight to the I-140 stage. The waiver is a little bit tough to get, but it is easier than the extraordinary ability category. Most of you could potentially qualify for a national interest waiver. Okay, so keep that in mind. EB1, as I mentioned, we really have to show sustained national or international claim. It's all about reputation. You've got to show some evidence in that in 3 of the listed categories that we mentioned before. But just having some evidence in each of those 3 categories is not enough by itself to qualify in that category. You have to show that that evidence as a whole really demonstrates that you have that sustained national or international reputation. It doesn't have to be in the U.S., it could be in your home country. But it's really all about reputation, okay? These are the criteria. They're really the same as the O1. Generally speaking, most postdocs, if they're going to try this, have published papers in peer-reviewed journals or major media. Many people have been served as a reviewer for a journal or a conference. That qualifies in the judging work of others category. Original contributions of major significance. So if you've worked on something that was published or invented something that was applied for a patent, that usually qualifies. Those are the 3 we see most commonly. The things you can do to improve your chances in this category. One is to join professional associations. So just being a member of a professional association where you pay dues is not enough. You have to have a higher level of membership in that association that requires outstanding achievements to be a member. But if you can do that, that is one thing that you can do to sort of help yourself. Second thing is to try to get yourself into the major media. Okay, so if you're working on a collaborative research project and they're looking for a spokesperson to talk to the press, that needs to be you. You need to get your name out there. Because articles in the press are one way that you can really demonstrate that reputation. So the more you do that, the better off you are. The third thing that really helps a lot in this category is networking. You want to be networking with as many high-level prestigious people you can because you need them to write letters of endorsement to sponsor this case. They're not sponsoring you, but they're really talking about what your achievements are and why you have this national or international reputation. The more people you get to know, especially those really high-level professors and scientists, and especially those grant people at the agencies that are looking at the grant proposals and managing grants, those are the people you want to get to know. And the more you do that, the more networking, the more of those letters from prestigious people you have, the better off your chances are. Outstanding researchers and professor, these are the criteria that we need to show. You need to have evidence in 2 of these criteria. So the most common ones, again, are going to be the published papers and the original scientific contributions. Most people can show that in some way, but again, it is going to be dependent on some letters in the field. The national interest waiver, we're really looking for 3-part standard test, and it's a super vague test. There's no evidentiary criteria like there are in the other categories. It's very vague. It can be in any field. They're looking for 3 things. The first one is the work you're doing in an area of substantial merit and national importance? So pretty much any scientific research is going to meet that point. That's an easy hurdle. Next one is, are you well positioned to advance this type of work? So for that, they're really going to look at your track record. They're going to look at what you've done so far. What kinds of contributions and discoveries have you made? What kinds of papers have you published? What kinds of job prospects do you have? And are you in a position where you're really able to make a difference? And the third one is the most important one, and it's a balancing test. This category was put into place because the government recognizes that labor certification process doesn't work for all jobs. So for the university academic positions, for example, they made this sort of special handling labor certification process because they realized that universities don't want to hire the least qualified candidates. They need the best and the brightest. This is sort of designed to kind of address that as well outside of the academic field. You can still apply for it in the academic field, but it's really designed to address outside of that. So it's looking for those areas where you really can't go through the labor certification process, either because you don't qualify for the labor certification process, or because it's the kind of job that you really can't measure in minimum criteria. Okay? So the kinds of people that won't qualify for the labor certification process are people that don't have a full-time permanent job offer with a U.S. employer. Postdocs. It's a limited job offer, right? It has an end date. It isn't an ongoing permanent job. So that is one of the main categories of people that try national interest waivers, because you're not eligible for the labor certification unless you get a permanent job offer. It also lends itself to any creative field, which includes research, because it's really hard to measure that kind of ability with minimum objective criteria. So just because someone has a PhD degree and 2 years of work experience doesn't necessarily mean they're going to excel at research, right? It depends on their creative ability, their past research that they've already done, and their role in whatever they're doing now. So oftentimes we can demonstrate that forcing an employer, even if you do qualify, if you're not a postdoc, even if you are in a regular associate research position or something like that, we can show that the employer really can't hire anybody else but you, because you are the one who developed this research protocol. You're the really one that's driving this. And if they had to stop and fill your position with somebody else, this research wouldn't go forward. That's a really good argument for this one. The labor certification process itself is designed to protect working conditions and salaries for American workers. It's designed to make sure that American employers are not tempted to hire foreign nationals at lower salaries and bad, terrible working conditions. So that's the whole goal of it. What we're trying to do with the national interest waiver is to show that the work you're doing and the benefits you're going to bring to the United States outweigh that protection to the workforce that the labor certification process is designed to protect. So you want to show, look, this is really important research. And the way you do that is show, look, I'm working on this research that's funded by, whatever national agency. It's a 3-year research project, and if I have to leave in the middle of this research stops. These often are successful.